Well, good morning, everybody, and thank you for joining us today for the RTA webinar. Our topic today is the Residential Tenancies and Rooming Accommodation Regulation 2025. That's a good start. And a recap of the May 1, 2025 rental law changes. Before we start, I'd like to acknowledge the traditional owners of the land on which we meet and where you are joining us from as well, and pay our respects to elders past, present, and future. So my name is Mark Fiddler. I'm joined today by Cassie Chow. Morning, Cass.
Good morning, Mark, and good morning to everybody who's joined us today.
So Cass and I are both senior community education officers with many years' experience in various areas of the RTA, including plenty of time in the contact centre, as well as our frontline support teams and the rental sector education. So we'll be taking you through what we have to discuss today. So we will be sharing with you, as I said, information about the RTA, background of the rental law changes that have occurred since 2021. We'll have a detailed recap of the changes that started on 1 May. And then Cass will go through the changes or the introduction of the Residential Tenancies and Rooming Accommodation Regulation 2025, which started on the 1st of September this year. And then we'll have a look at your questions. Now, we would encourage you to use the chat to ask your questions. We'll get to as many as we can, but the focus today will be on questions relating to the information that we provide. We have seen some comments in the chat, so that's the best way to get those questions into us. So just a quick recap, who are we? What do we do? So those that aren't familiar with the RTA, we are an independent statutory body. We administer Queensland rental laws. We don't write the legislation. However, we do and can and do provide sector insights to the Department of Housing and Public Works, which is responsible for writing the legislation. So our role here at the RTA is to help all parties understand their rights and obligations and to provide them with the best opportunity to maintain successful tenancies. So we are here to help everyone involved in a tenancy. So our services include our contact centre, our free dispute resolution service. We carry our compliance and enforcement activities to uphold and enforce compliance with rental laws. We look after rental bond management. And then we do a lot of work with stakeholder groups such as the RERQ and Tenants Queensland, and provide education through our resources such as hosting webinars like today's, hosting podcasts, and looking after fact sheets and the information on our website. So just quickly, we know that there's been a lot of change over the years. So a quick look at where our journey has come from. So it started back in 2021 with the Housing Legislation Amendment Act of 2021. So the key changes were implemented across a period of time. So implemented in stages during obviously 2022, 23 and 24. And you can see on the slide the various introductions through those periods. Last year, the Residential Tenancy and Rooming Accommodation and Other Legislation Amendment Act of 2024 was passed. Is a mouthful, appreciate that. And again, the key changes within that were implemented through a staged approach in 2024 and 25. So the last changes there were on May 1, and just recently, the 2009 regulations were updated, and the new regulations commenced on the 1st of September 2025. So we'll have a look at the May changes to start with. Obviously, these have been in for about 6 months now, so hopefully most people are reasonably familiar. So just in regards to entry notices, so entry notice periods that were previously 24 hours were increased to 48 hours. So these are for situations like showing a prospective tenant or purchaser, your maintenance checks, smoke alarms, valuation. So there is an exemption for cleaning in a rooming accommodation agreement, and keep in mind that mutual agreement is still available as an option for entry. Once a notice to end the tenancy is issued, whether this is a notice to leave or a notice of intention to leave, then the frequency of entry has been limited to no more than twice in a 7-day period. Now, the intent of this was to help ensure quiet enjoyment for the tenant when their tenancy is ending and they're in the process of preparing to move. So, as per the slide, limited entry frequency does not apply for things like emergency repairs, compliance with smoke alarms and safety switches, or mutual agreement. Cass, is there anything else that people need to be conscious of with regards to this?
Well, yes, something to be aware of here is that if there's a selling agent or another person looking to gain entry who is different to the managing agent, they need to be aware of any notices that may have been issued to end the tenancy. And we're also aware of practices where a notice to end a tenancy is issued when the tenancy starts. And that will restrict the entry frequency for the full length of that tenancy because the notice has been served already.
Yeah, all right. Thanks for that, Cass. That's good to know. All right, so
Thank
let's have
you.
a quick look at personal information. So, other changes that were made in May. So, obviously, in today's world, protecting privacy and personal documentation is important to everyone. So, in most cases, personal information will be the identity documents or any other personal information collected within the application process or during the tenancy. But it can also include photographs or images of individual personal possessions or their standard of living, which may have been taken as a part of a routine inspection or advertising. So it's important to understand there's limits that apply to the personal information that can be requested. And also there's now a time frame outlining the secure storage and destruction of personal information. So the time frames, which we'll talk about here. So if it's three months from the start of a tenancy. So all the applications that you receive, obviously only one of those applications is going to become the tenant. So those prospective tenant applications, they need to be destroyed within 3 months after the start of the tenancy, unless the tenant agrees in writing for their application to be kept longer. When it comes to the end of the tenancy, so the tenant that becomes the tenant, or the person that becomes the tenant, so 7 years after the end of the tenancy, all of the personal information relating to the tenancy needs to be destroyed. Now, it's worth noting here that this applies to physical and digital and email records. It doesn't matter where the information is stored, whether it's in a cloud, an offshore system, the legislation applies and all personal information must be securely destroyed. Cass, can you give us an example that applies here?
Well, Mark, an example might be that if you're a property manager and you have taken photos during a routine inspection, which you then send to the property owner, you'd need to make sure that you delete the items from the sent items box in your email system, as well as anywhere else those photos might be.
So it's important to make sure that you keep a track of where you are storing data and get and
Yeah,
destroy it within
absolutely.
those particular timeframes. Yeah,
Mm.
very good. All right, just in regards to request for fixtures and structural changes. So May 1 saw a change that puts an official process around the request for fixtures and structural changes. So if a tenant's looking to hang a picture or put up a shelf or even add an air conditioner or some other fixture, there is now a Form 23 for the tenant or resident to complete when requesting such a change. So the tenant needs to provide as much information as they can. The property manager or owner now has 28 days to respond to the request. Now, it's important to note here that if there is no response, then it's not automatically approved. So this is not like the old pet or the pet process, whereas if you don't respond in 14 days, the pet's taken to be approved. This is just formalizing this process and putting some timeframes and a framework around it. So it's not an automatic approval. The other thing is that approval must be in writing and you have an opportunity to describe the fixture or change and any specific conditions that you want to go along with the tenant adding that change. Cass?
Yeah, so I just wanted to highlight here that some examples of the conditions that might apply are listed on the slide. And we also recommend reading the form for important information. So, in particular, just note that page 3 of the form has a section for the managing party to respond to the tenant. So, everyone, please ensure you have a careful read of that form as well.
Fantastic. All right, and just one of the other key changes that was introduced on May 1 was the standardised rental application form. Now, again, as I mentioned, this has been in place for about 6 months now, so people are obviously becoming familiar with the form and its use. There's two forms. One is a Form 22 for general tenancies and movable dwellings, and then there's the R22 for rooming accommodation. Now, obviously, these forms must be used when a prospective tenant is applying for a rental property. Property managers or owners also need to provide two ways to submit an application and ensure an option to submit the form is available other than using a restrictive way. Now, restrictive in a practical sense is if a manager or owner uses an online or a digital application, you'll also need to ensure that you offer another option such as a paper form or email, or just to ensure that it's accessible for all prospective tenants. Now, the form includes all the questions that can be asked of the applicant, along with the ability to request documentation from the applicant to support their application. So the slide shows the categories that you can request no more than 2 documents from the tenant, but be aware that obviously the tenant can voluntarily provide more. You'll also note the asterisks on the slide. Now, when it comes to identity documentation, a prospective tenant may choose to show or provide a copy of their identity documentation. If they do show you a copy, you are able to take notes of the details on the ID. I appreciate that's a brief recap of those changes. There is a lot of information on our website, and I will drop some links into the chat around some of those particular things. Cass, anything else that we need to be aware of here, or any common questions that we see coming through?
Well, just a couple of things to be aware of here is that like some of the information that a property manager or owner is not permitted to ask about includes evidence of legal actions taken by the prospective tenant, information about previous breach notices that the tenant has given or received, like in a previous tenancy, say the prospective tenant's history relating to rental bonds, or any claims that they've made on a bond, say, and statements that detail a potential tenant's credit or bank account history.
Yeah, good point. So those things again are listed in more detail on our website. So if you are looking for more details around that application process, we suggest that you jump on and have a look on there. I did ask you, Cass, about questions. I have just had a quick look myself. So there are a few in relation to the ending a tenancy. So if a notice to leave or the notice of intention to leave is issued, entry is limited to 2 entries within a 7-day period. So I think one of the questions here is, can only 2 entry notices be issued? Well, no, 2 entry notices within a 7-day period. So there might be things like repairs and that need to be done as the tenancy goes along, or as that ending period goes along. So you're not limited to 2 for the full period. It's 2 within a 7-day period. And another question, if you issue a notice to leave with a renewal, so if you're sending out a renewal a couple of months before and also a notice to leave, giving the tenant a choice, then yes, that 2 entry notice, at frequency of 2 entries would apply in that situation because you have actually issued the notice to leave. So I'll keep looking at these questions and we'll come back to a few more at the end of the session. I'll let you continue on, Cass.
Thanks, Mark. So we're now going to share some information about the changes that have been made to the Residential Tenancies and Rooming Accommodation Regulation. But we will start with firstly discussing what a regulation is and why it matters. So a regulation is a more detailed rule to support and explain the Act, which for Queensland tenancies means the Residential Tenancies and Rooming Accommodation Act of 2008. This Act is supported by the Residential Tenancies and Rooming Accommodation Regulation, which you may or may not be aware of. And the regulation was reviewed this year by the Queensland Government. And on the 1st of September 2025, the previous version of the regulation of 2009 was replaced with the regulation of 2025. Now, to illustrate how the Act works with the regulation, we do have here a couple of extracts. Now, on the left-hand side of the slide, you'll see an extract from Section 363 of the Act, which specifies some criteria for the immediate sale or disposal of goods left behind in a general tenancy. This includes that they may be sold or disposed of if the market value of the goods is less than the prescribed amount under a regulation, which we've highlighted. It also specifies that if the criteria for the sale or disposal are not met, then a former lessor must safely store the goods for the minimum period of time, and again, prescribed under a regulation. So it is making reference to the regulation there. And then on the right-hand side, you'll see we've placed an extract from the 2025 regulation. This specifies that the prescribed market value for goods other than those relating to a movable dwelling site only is $2,500. And the prescribed minimum storage period for goods other than a caravan, its contents, and other goods used in occupying the caravan is 1 month. So therefore, if we combine the information from the Act and the regulation, we could work out that, for example, if a tenant in a general tenancy left behind goods to the total value of $3,000, which also meet other requirements specified under the legislation, such as being safe to store, then the property manager or owner would be required to store the goods for at least 1 month. So in that example, we're just combining the information from the Act and the regulation to work out what we need to do with these goods left behind. Now here we have another example of the way the Act works with the regulation for water consumption charges. On the left-hand side of the slide, you'll see an extract from the Act which details the circumstances under which water charges may be passed on to the tenant, including that the lessor must provide the tenant with a copy of the relevant water bill. And on the right-hand side, there's an extract from the regulation which states that the lessor must give the tenant a copy of the water bill within 4 weeks after the lessor receives the documents, and that the tenant must then pay the charges within 4 weeks after the lessor gives the tenant a copy of the water bill. So the regulation doesn't change the Act. It helps support the RTRA Act, and it puts a practical aspect on certain processes. With all the rental law changes over the past few years, the 2025 update tidies up the old regulation. The regulations specify the standard terms in a tenancy agreement, which are the middle section of general tenancy, rooming accommodation, and movable dwelling agreements. Now, some key changes to the agreement forms include reordered item numbers, some updated wording, and improved clarity of the standard terms, which reflect like regulatory requirements and aligns with the Act. And I just want to note here to remember to always use the latest versions of the RTA forms to make sure that you have the latest one. A transition period does apply for the regulation updates. What this means in a practical sense is simply existing agreements entered into before the 1st of September 2025 remain valid. There's no need to do a new agreement. However, any agreements entered into on or after the 1st of September need to comply with the new regulation of 2025. Now, one of the key messages that we do want to deliver here to everyone is to know when the agreement was entered into, to know which of the regulations apply. So moving on to goods left behind, and I can see a few questions that have been raised in the chat about this, so we will address those later. As we mentioned earlier, the regulation sets the threshold value and minimum storage period for goods that are left behind by a tenant or resident. The key points to be aware of with goods left behind are, 1, for general tenancies and rooming accommodation, threshold values have increased, but the storage periods have remained the same. And two, there's been some updates to both the values and storage periods for movable dwellings. And what you'll see here on the slide is that we've highlighted where there's been a change. But we would encourage you to access our website and fact sheets for detailed information if and when you need it in relation to goods left behind. Mark, is there anything else that you're seeing in the chat or that people might need to know here or need clarified?
There are a few questions, Cass, that are coming through around the goods left behind process. I'd encourage people, without getting into too much detail around that,
Mhm.
but I'd encourage people to jump on and have a look. I have just tried to drop a link in, but it didn't seem to work. But I'll get that working
Mhm.
around that process. So uh, questions, is there a guideline for determining the market value of goods? There isn't, but we'd suggest using, things like Facebook Marketplace or a second-hand dealer. The key there is really to document what has been left behind and how
Yeah.
you have come to a value. Can you simply dispose of it if it's under a certain value? Yes, you can, and obviously the values are up there on the slide at the moment. So, but we'll keep moving, but I would encourage people, if they're not sure about that process, to jump on and have a look at the fact sheets and the information on our website.
Yeah, absolutely. So the prescribed house rules for rooming accommodation have also been updated to clarify requirements relating to quiet enjoyment. However, the prescribed house rules in the 2009 regulation do continue to apply until the 31st of August next year. From the 1st of September next year, the prescribed house rules in the 2025 regulation will apply to all agreements. So the regulation provides examples of electronic communication types for notices. These include email, fax, and now also text messaging. The RTA tenancy and rooming accommodation agreement forms have been updated to reflect this. So there are tick boxes now added to allow parties to indicate whether they will accept text messages for the delivery of notices. I'll just add here that it's important that all parties do take the time to indicate clearly on their tenancy agreement which forms of communication may and may not be received, not be used, sorry, may or may not be used for receiving notices. So just to give you an example, if you're an agent and you don't like receiving notices by text message, then make sure that you do tick no beside the box that says text message. Some of the other noticeable changes to the regulation include the time frame for paying water bills has changed from 1 month to 4 weeks. Some sections relating to pets and rooming accommodation have been renumbered. There's some clarification around who is required to be contacted in an emergency repair situation. And for rooming accommodation agreements, there's a tick box for the services to be provided in terms of whether you are a level 1, a level 2, or a level 3 service provider. We've now summarised the key updates to the regulation, and we'd like to reiterate the importance of knowing when the agreement was entered into, what the standard terms are of that individual agreement. If the agreement was entered into prior to 1 September 2025, then the 2009 regulations apply. And if the agreement was entered into on or after the 1st of September 2025, the 2005 regulations apply. Mark, are there any common questions coming through the chat about them?
There are, Cass, and I would continue to move on. So that gives me a chance to collate
Mhm.
them all and make sure that we can address them
Address them.
once you've finished. Yep.
Okay, excellent. So, one final reminder, you may remember that back on the 30th of September 2024, the requirement for evidence supporting bond claims to be provided to a tenant within 14 days was introduced. Now, there was a 12-month transition period, which meant that this requirement did not apply to bonds lodged with the RTA before 30th of September 2024. Now, we'd like to remind everyone that this transition period ends on the 29th of September 2025, so coming up soon. And this means that from the 30th of September this year onwards, evidence must be provided to the tenant or resident within 14 days for claims made on any bond, regardless of when the bond was lodged. And if you didn't know this already, customers can access the RTA website and get copies of the Pocket Guide for tenants in 9 different languages. Customers calling our contact centre can request access to interpreter services. And recently, the RTA also introduced a dedicated phone line for our Aboriginal and Torres Strait Islander customers. And this is called Songlines. More information about Songlines can be found by scanning the QR code that you'll see on the left-hand side of this slide. And the phone number for Songlines can be found on the RTA website by typing Songlines into the search bar. Now, we're sure, well, we know because we can see it in the chat that you have questions about the information that we've shared today. So if there are any further questions, just please place it into the chat and we'll do our best to answer as many questions as possible in the final few minutes of this webinar. So, Mark, what have we got out
All
there?
right. Thanks, Cass. There have been plenty of questions coming through. I saw a number of questions through there around can an agency and variations of can an agency request from another agent if there's been breaches and those sorts of things, if the tenant has provided the agent as a referee? The answer is there, yes, you can. You can ask any questions of a referee. You just can't ask those questions specifically from the tenant. So we did have about 3 or 4 questions around that.
Mm-hmm.
Another question, and just to confirm, around ID. If the tenant shows their ID at an open home, for example, are we legally allowed to write down the note or the information, or are we only allowed to view it? No, you can make notes in regards to, if it's a driver's license, you can take the driver's license number and the address and those sorts of things. So no problems doing that. REIQ was recommending to issue a notice to leave with a lease, but I'm confused as this may conflict if the property is listed for sale. Yeah, so the point that Cass made when we talked about that notice to leave and the restriction on entries, if the notice to leave is issued at the start of a tenancy, and we understand that that was a practice that was occurring from some time ago, then you will be restricted to no more than 2 entries in a 7-day period for the term of the tenancy, because effectively that notice is in effect for the term of the tenancy. If I send a routine inspection to an owner, do they then need to destroy evidence after 7 years? Yes. So the interesting or the key here is that regardless of where that information is stored or who it is stored with, then the requirement is that 7 years after the end of that tenancy, it does need to be destroyed. Someone's asked us to provide some examples of evidence in regards to the bond. So there's no specific definition of evidence within our legislation, but the examples that the legislation uses are things like receipts, rent ledger, in effect, anything that shows a dollar value. So you can't just say, well, here's the entry condition report and here's the exit condition report. They don't match up, so we're claiming your bond. You've got to give the tenant a reasonable amount of information that shows what that claim is looking for. So it might be a quote, for example. There's a question in there, does it evidence of a claim have to be invoices, or if I'm claiming for cleaning, can it be photos of a dirty property? It would need to be at a minimum, I would suggest, a quote in regards to that circumstance, because the tenant really should be provided with a dollar value of what the claim is for. What else have we got in here? In relation to fixtures, what if it's grab bars into tiles? What kind of good can you enforce if your tiles are rolled, etc.? So one of the conditions that you can actually apply, and this is why Cass encouraged people to have a good read of the forms. One of the conditions that it can apply is that it's professionally installed. So if you've got concerns, for example, about the condition of the tiles or how that grab rail needs to be applied, then you can request that the tenant have something professionally installed. So that you can also then ask that it be returned to the condition at the end of the tenancy, or you could ask them to leave it there. There's a whole range of different conditions that can apply in those circumstances. What else have we got in here? And I'm conscious of time.
Yes, time.
Yeah. Link. Um, yeah, a lot of them are similar to what I've sort of discussed a little bit. Do we need to delete all the information regarding the tenancy after 7 years, including rent ledgers from software? Does that mean any tenant reference older than 7 years cannot be given to another party requesting a reference? The requirement to securely store and then destroy after 7 years covers all the personal information relating to the tenant within that tenancy. So we can't provide legal advice, obviously. So you may need to check in regards to what needs to happen there, but ultimately the legislation states that all personal information relating to the tenancy needs to be destroyed. So I would suggest that the answer to that question is probably yes, but without wanting to get into legal advice, I'd also suggest that that get checked. So, all right, I'm conscious of time, Cass.
Mhm.
Appreciate that. We've still got about 360 odd people sitting here listening to us, but we
Yes.
did say 30 minutes.
Yes.
So I'll stop talking now, and you
No,
can finish up.
that's good. Like we do appreciate everybody that there were probably several questions asked that we didn't get to, or that didn't relate to the topics we discussed. So if you do require some information about your specific circumstances, please feel free absolutely to call our contact centre so that we can help you with those. And that concludes our presentation for today. As after we close this webinar, you will receive a link to a survey that asks you to share ideas for future webinars. This provides you with the opportunity to provide us with topics that will best help you with renting or managing tenancies. And we are really keen to hear from all of you. So please do complete that survey. And thank you to everybody for joining us. Thank you, Mark, for being here today as well.
Thanks, Cass. Been a pleasure.
Uh, Absolutely. And we look forward to seeing you at one of our free information sessions or webinars across the coming months. This webinar will now close. Thank you, everybody.